Legal 116, this is your podcast for week numbers 7 and 8 when we move into drafting a complaint. I've asked you to do some reading and prep work before you listen to this podcast, and hopefully you've done that. If you haven't, go back and do that. And if you have done so, then you should be able to explain what is meant by a cause of action, explain why pleadings have numbered paragraphs. You should be able to explain or identify the requirements for jurisdiction in a lawsuit, to determine the appropriate venue for a lawsuit and know the difference between jurisdiction and venue, things that we actually covered almost half a semester ago. Excuse me. You should be able to differentiate between fact pleading and notice pleading and what those two things are, and then know what Illinois expects. You should appreciate the usefulness of form books and secondary sources like the resources that you have available to you through our ICC library, the IICLE, Illinois Institute of Continuing Legal Education, or ICL resources that you have available for every class topic and anything regarding the law. Most law firms or lawyers pay a lot of money, and most law firms do not have access to the full amount of materials that you have access to while you're here. So that's a great benefit. But those are the kinds of things that lawyers look to unless they do certain things over and over, a certain type of practice, and then you probably have your own forms within the office. But if you don't have those forms, or you don't have forms on a certain thing you don't do often, it's always good to go back to these form books and secondary sources like ICL. You should be familiar that you need to ensure your client's right to a jury trial has not been waived, that they have demanded their jury trial, or right to a jury trial, if that's what they want. You should be able to identify the two key purposes of a summons. What a summons is, of course, but then what the purposes of that summons are. And you should be able to explain the difference between in-hand service and abode service and know what abode means, as you are able to distinguish between in-person service and abode service. So a complaint is a formal statement of a plaintiff's cause of action or causes of action seeking legal or equitable remedy against one or more defendants, which, when filed with the court and served upon the defendants in the required manner, successfully commences a lawsuit. Now that's a different definition than what you might have learned if you had me for criminal law or CRJ 227 or CRJ 230, and we might have talked about a criminal complaint. Much different animal, same purpose, but it's different. And again, remember, we're talking about civil things. Nobody's going to jail. Nobody's getting punished. 735 ILCS 5/2-201 tells us that a complaint sets forth who the parties are. It advises the court and opposing parties of the plaintiff's cause of action. It has to use clear and concise language and contain a prayer for relief. You should have that section of the code in addition to Part 6 of the Illinois Code of Civil Procedure, more specifically 735 ILCS 5/2-601 through 2614, handy anytime you're drafting one of these documents, a complaint, or any pleading, really. Have this information at your side or on the screen as you begin to draft your complaint, and check that your complaint meets these requirements. Now, if you have a tried and true form that's used in your office or you got from ICL, by all means use that form, but go back and make sure that the form complies with the expectations of the Code of Civil Procedure. A complaint in Illinois must contain substantial allegations of fact, enough facts to state a cause of action. Similarly, all pleadings have to contain plain and concise statement of the pleader's cause of action. That includes counterclaims, defenses, replies, anything that we've file in court as a pleading. And the Supreme Court's held that a complaint is deficient if it fails to allege the facts necessary for recovery. In Chandler versus Illinois Central Railroad, 207 Illinois 2nd 331 at page 348, a 2003 Illinois Supreme Court case, the court said the complaint must set forth the ultimate facts needed to prove the claim, but not the evidentiary facts which tend to prove the ultimate facts. Now, I alluded to this a little bit when we talked about you going out to investigate the scene. Just like the investigation doesn't seek to prove the case, the complaint does not seek to prove the case. We don't have to go to the extent of stating evidence or all the evidence that we will eventually enter into the record, present to the jury if we have a jury, through witnesses who are sworn to testify and put on the witness stand in court. But we are required to provide the defendant with notice of what the general facts are that we claim are the result of their negligence, in our case. How did they drive, or what expectations for them driving the vehicle were violated? What were the facts regarding those things? Did they fail to yield the right-of-way? And then we have to say how they failed to yield the right-of-way. Generally, stating facts that describe, if you think back to the police or the accident report and then your review of the accident scene, what were the facts? How did that accident occur? And those, how that accident occurred, the how or the what the defendant did are the facts. Just the general facts. They failed to see the vehicles ahead of them. Did they fail to stop and yield the right-of-way? Did they fail to slow the vehicle? Facts like that. That's all we have to do. You don't have to go into every specific detail and give a paragraph. A couple sentences or a sentence sometimes is enough. And that case also said that separate factual allegations should be arranged in separate and consecutively numbered paragraphs. That means that when you get to the negligence section of your complaint, if you've looked at the forms that I suggested that you take a look at, or you get into ICL, and especially in the next week or so as you're trying to figure out what your complaint's going to look like, when you get to that negligence paragraph, that's the paragraph that comes after the paragraph that alleges the defendant had a duty and breached the duty, and then it goes into an explanation of how the defendant breached that duty, and typically those are in outline format, small a's, indented, smaller paragraphs. They're separated. And so failure to yield is different than failure to stop. Failure to stop is different than failure to see. Failure to see is different than failing to reduce your speed. If you think about all your duties in driving a vehicle, it usually comes down to your ability, an expectation that you see the traffic ahead of you, that you keep your vehicle in safe operation on the roadway, within the lines, within the expectations of a lane. You're not driving in the opposite lane or the wrong lane in the wrong direction. You can slow a vehicle. You can stop a vehicle. You can turn a vehicle. So all of those things, those are separate allegations. They need to be in separate paragraphs, and you need to support those allegations with facts. And if you did go and look at the Illinois Vehicle Code and look at the different things that you can have held against you as a violation of the Illinois Vehicle Code, everything I just said falls in there, right? A complaint that does not put the defendant on notice of facts necessary for the plaintiff to recover fails to state a cause of action. And that's an Illinois Supreme Court case, Gonzalez versus Thorek Hospital Medical Center, 143 ill 2nd 28 at page 36. That's a 1991 case. So essentially, if you don't state a cause of action, your complaint can be dismissed. Now, we get into dismissals, and you can look ahead at that. 2615 and 2619. 2619 is fatal. Then your complaint goes away, your case goes away. And so if you do something, or if the facts aren't there to prove a claim or to allege a claim, or one of those other things listed in 2619, well, your complaint can go away, your case goes away, and that's fatal. Most motions to dismiss on complaints that you will deal with will be 2615. That still means that the court can dismiss your entire complaint. Now, you may get time to come back to plead again or to fix the things, and in most cases, you just have certain sections stricken because you didn't do a sufficient job, say, in the negligence, and that's typically the area that people fail. Negligence allegations, you didn't tell the other party sufficiently, the defendant or their counsel, sufficiently in facts, what it is you allege they did wrong, or you didn't do it clearly enough. And we'll talk about that more when we talk about motions to dismiss. Each count of the complaint has to have a specific prayer for relief. And if you've looked at multiple count complaints, you can allege negligence against one party in one count. If there's two defendants, you'd have to separate the negligence allegations for the other defendant into another count. Or if you're seeking other relief that's different in multiple counts, you have to separate those allegations out into multiple counts. Now, you can repeat things. For instance, if the first 3 or 4 paragraphs of count 2 are exactly the same as count 1, you could say repeats the allegations of paragraphs 1 through 5 of count 1 if it's against the same defendant. But you have to separate those things out. As we've talked about, civil law for the most part is civil and it's not punitive. There is a thing such as punitive damages, and I think I spoke about this before. They should not be pleaded in the complaint, and that's, if you look at 5/2-604.1, you have to file a pretrial motion and request a hearing on punitive damages. As I said in prior weeks, the court can allow punitive damages if the party establishes a reasonable likelihood of proving facts at trial sufficient to support an award for punitive damages. And that's a whole other analysis that we aren't going to spend any time on because it doesn't come up that often. And if it does, either make sure your lawyer has done it before and knows what they're doing, or they've engaged another lawyer to help them navigate through requests for punitive damages. I've asked that you take a hard look at the different parts of the complaint. And the caption, the purpose and function of the caption, it's the title of a court document. It's the heading or introductory clause that shows the name of the court that we're going to, the county and jurisdiction where the action is brought. So it shows us the court that has jurisdiction, the county, so in the Circuit Court of the 10th Judicial Circuit, Peoria County. Remember, there's 5 counties in the 10th Judicial Circuit, so we would name the county. That's where the case is going to be venued because that's where the accident occurred most likely. Although with the complaint, the court number, which is you'll see on court documents in this section, it won't appear until the case is filed. So you're not going to have a court number until after we file the complaint. And I'll give you that court number later. So don't insert a court number on your draft or especially your final draft, because the reality is you don't get a court number until your complaint is accepted and filed by the clerk of the circuit court. That caption sits above the title of the document and the introduction paragraph. And the title of the document is just, for instance, in this case, it would be complaint. In the introductory paragraph, if you've noticed from the various forms that I gave you to take a look at, it's where there's an introduction as to who the plaintiff is and who they're represented by and what they're seeking. Sometimes states who the defendant is and then what they're seeking for their complaint on acts of negligence state that. And then it goes into the counts. Again, as I said, if you have different counts for separate causes of action, then you need to split those out. For our Week 8 complaint, you will not have separate counts. You only have one count, and it's based on negligence. So hopefully you listen to this and you hear me now and you don't add a bunch of other stuff. You should only have one count based on negligence. Some items that may need a bit of explanation because it's often the case that we have more than one plaintiff or more than one defendant in a given civil case, especially negligence cases. The concept of joinder, which you might have read about. Joinder is the right of two or more parties or plaintiffs to pursue common claims in one lawsuit. Also, the right to file one lawsuit against two or more defendants. In other words, it's the same thing, it's the same action that created the damages for the plaintiff or plaintiffs, and you only have one lawsuit. So you're not having one or the other party have to fight two lawsuits, distinct lawsuits from different things. The example I always use is not as much since COVID, but for many years prior to COVID, about every time it would turn cold and we get our first little snow or ice, there'd be a pile up on the Murray-Baker Bridge going into or out of Peoria at the end of the day or the beginning of the day because so much traffic was coming in and out, people working downtown, etc. And there would be these multi-vehicle rear-end pile-up accidents. So you might have 5 cars involved in the accident, and it may be that the first vehicle did nothing wrong other than slow for vehicles ahead of it, and it got rammed by the second vehicle. The second vehicle got rammed by the third vehicle that was following it too closely, and the fourth vehicle hit the third vehicle, which also hit the second vehicle. The fifth vehicle may have come along, hit the fourth vehicle, and then the fourth vehicle didn't get pushed any further into the other vehicles. All kinds of different combinations, but all based on the same initial chain of events. And so if there, depending on how liability came out or how liability was alleged, you would have those cases joined together. That's different than counterclaims and cross-claims. So a counterclaim is a cause of action filed by a party against an opposing party in a responsive pleading, usually by the defendant against the plaintiff, alleging some action by the plaintiff. That's something that you'll see. That's something that you should remember when you do see it. I won't spend a lot of time here, but know it exists. So it's possible for the defendant to essentially say, well, too bad, you're at fault. And they file under their own cause of action. And if they have enough facts to allege whatever that cause of action might be, they have a counterclaim. Now, cross-claim is a cause of action filed by a defendant against a co-defendant, typically alleging that the co-defendant was solely or primarily responsible for the action. Go back to my rear end pile-up example. You can see where, one driver or the other might blame the other drivers. There's probably a few cross-claims in that type of case. You probably read that some claims must be verified, and if you had family law in the spring, and if you're going to have it in the next spring, you can remember this. But those of you who had family law know that divorce petitions, a divorce petition is a complaint for divorce. A divorce petition must be verified. Certain complaints must be verified, and the statutes will tell you that. So the family law statutes tell us that the complaint must be verified. Complaints and pleadings offered behalf on corporations in certain types of cases are required by statute to be verified. So petitions for dissolution, those corporation type of cases, they have to be verified. Verification is when the plaintiff or its agent verifies the complaint by attaching a page at the end containing a statement under oath that says the plaintiff has reviewed the complaint. Regarding the allegations of which the plaintiff has personal knowledge, the plaintiff knows or believes them to be true. And regarding the allegations of which the plaintiff does not have personal knowledge, the plaintiff believes them to be true based on specified information, documents, or both. I asked you to be aware of service of process. Now, service of process in federal courts and in Illinois and most states, but especially in Illinois, the sequence is this. You file your original complaint with the court. You have a summons and copies of the complaint served on the defendant. And there's a number of ways to serve and look at the statute. After service, you file a return of service with the court. And that dictates when the defendant must appear, when they must come in to appear and or answer or file their motion to dismiss or whatever. So let's talk about service of process in Illinois. In most civil actions, service can be made by the sheriff or court-appointed process server. In Cook County, original service has to be by the sheriff. It's always important to look at what's required jurisdiction-wise. So go to find out if a certain circuit, or Cook County is its own circuit, but any of the other circuits, multi-county circuits, what's required. Now, service of summons shall be by personal service, leaving a copy with the defendant personally. So you have to identify, this is the defendant. And then you have to leave it with them. Once you've identified the person, you leave it with them, and then the process server says, I left it with John Smith. The person identified himself as John Smith. Now, how does this work? Typically, it works just like that. You go up to the person, say, hey, are you John Smith? You are. Okay, here you go. And you're served. At one point in my life, when I had left, went to work for a law firm full-time between law enforcement and getting my law license while I was going to law school, I was serving process. And the lawyers would have me appointed by the chief judge to go and serve processing cases, and I'd go out and hunt the people down and serve them. Some people would try to be shifty and get away from you and not be found, and others just walk up to them and you'd identify that was the person, and you just give them the copy of the summons and the complaint. There's also Abode Service or substitute service, and that's where you can leave a copy at the defendant's residence with a family member or person residing there of at least age 13 with information as to its contents, and then sending a copy by mail. You need to find a copy or an example of a Peoria County civil summons for next week, because you're going to need to provide that with your complaint when you file your complaint. Now think about that, leaving it with somebody at least 13 years of age. I was never comfortable with that. I always had private process servers, and I want the person served. It's civil cases, so in most of those civil cases, you should be able to find the person. Sometimes people try to be shifty, as I said. But I wasn't comfortable leaving the document with somebody who was at least 13 or anybody at a house and hoping it got to that individual, even if you mailed them something else. Let me talk about forms for a minute. Most court documents look alike. the same parts and expectations because that is what the Code of Civil Procedure and the Supreme Court rules require. And that's going to be the case with complaints. It's sometimes a shock to students that this is an expectation. The content may be different facts, different legal authorities, different fonts. Be sure you check the fonts and see what's allowable by the courts, and slightly different appearances in the layout. But for the most part, the documents will appear to be very much the same as the complaint examples that you've reviewed this week. They sort of all look alike. Now, when you're filing motions and briefs in support of motions and a lot of legal research, well, that's still going to look a lot alike. It's just going to have more narrative in there, more of your argument. And in the complaints, as you notice, they're pretty scant. There are no arguments. You're just stating the facts. Just the facts, ma'am. Just the facts. There are always examples or forms of complaints, pleadings, and other documents available in law offices, especially for the types of documents we use often in a particular area of practice. And if you're out there working in law offices, you know this is true. You develop your own appreciation for certain forms, or develop your own forms that you actually somebody took at some point from some other form, whether that was Ickle or another lawyer or past lawyer or a lawyer 50 years ago, and you've just taken that form and updated till you have it today. It's a template to assist you to apply the facts of your particular case and make sure it's kind of like an ongoing checklist. I need to have these things. Okay, just put in your facts. But as I said before, be sure you have all the elements required by the statute or court rules at that given moment. So you go back and you look at the statute and those court rules to make sure that the version of the form you're using, the version of the template that you've applied, is consistent with the law. And if it's not, you update your form, right? That next complaint that you draft that is compliant with whatever changes have happened in the law, you update. Damages. Illinois Supreme Court Rule 222 provides guidance on damages, and it gives some jurisdictional limits. And it tells us what has to happen with those limits. It's either above or below. Now, we're not dealing with small claims, so don't worry about that. We're dealing with either the L cases or the LM cases, the above that amount, and I'm not going to state that amount right now. You tell me what that amount is. And you have to include an affidavit, a sworn statement by a person signing the complaint, the lawyer, if not a verified complaint, and the client, if it's verified, that says the case is seeking damages in excess of that jurisdictional amount or not. And you have to be very careful. For our purposes, in the complaint assignment that you're supposed to be thinking about your draft of this week and maybe doing some work on, our client's facing back surgery, a fusion surgery of his L5-S1 vertebra as a result of this accident. Medical bills will be in excess of or close to that jurisdictional amount. So we will be seeking damages in excess of that amount. We'll be seeking the highest level of damages the statute allows. So you have to include the appropriate affidavit for your lawyer to sign along with the complaint. And the lawyer signs this complaint. The client doesn't have to sign this complaint. This is not required to be a verified complaint. Use the forms in ICL to find that affidavit example and include it in your complaint after the signature line at the end of the complaint document. Now, you know you have that pending assignment for week 8 to draft a complaint. So use forms as examples to make sure you have included all parts and you've used proper format. Have the statute and Supreme Court rules accessible and review those items as you draft your complaint. Make sure you're complying with the law. Be sure you create a proper caption. Be sure you think about what I said earlier in this podcast about jurisdiction and venue and where this case is going to be venued, what court and where it's going to be venued, and how that fits into the caption. Remember, your paragraphs have to be numbered. You have examples that show you. If you can't figure that out and you come up with some whole different format, man, I can't help you. I gave you examples. You have ICL. And you've had me talking a whole lot about forms and using forms as a template. Your complaint has to include elements discussed previously for a negligence case: duty, breach of duty, proximate cause, and then damages. The breach of duty is your negligence complaint or paragraph that I talked about that has the subparagraphs that state specifically defendant failed to yield the right-of-way because he entered into the intersection at the same time the plaintiff was entering into the intersection intending to turn into the parking lot and struck the plaintiff's vehicle. Freebie. You have to spend some time working on your negligence allegations. Illinois Vehicle Code allegations we introduced and then began discussing a week ago. You have to remember, a complaint is not where you prove your case. It's merely where you provide sufficient facts to put the defendant on notice that what you allege the defendant's duty was, how the defendant breached that duty, and how that breach of duty caused your client damages, and in general terms, what those damages are: injured their lower back, requiring surgery, lost wages, but not dollar amounts. Though you do need to decide, and not dollar amounts in specifics like $1,272.43. You have to state the case is you're seeking in excess or below that jurisdictional amount that I just discussed. And don't forget what Rule 222 requires. Replay this as much as you want. I know it's a lot, and I know complaints are a lot, but we're in week 7 and 8. We're at the midpoint. And this is the birth of the litigation. You've done a lot of work up to this point, and now it's where we start into the nuts and bolts of what you're going to do in litigation. I appreciate your efforts the first 6 weeks. I look forward to seeing what you come up with your complaints. Eventually, you're going to be assigned to reply to the complaint of another student. In most cases, just based on prior semesters, 28 years of teaching this class, almost every complaint should receive a motion to dismiss. Most every complaint, or a lot of complaints that are filed by seasoned lawyers, see a motion, at least one motion to dismiss. It doesn't mean that it's going to be successful, but there's at least enough argument as to why, or that a good faith basis to bring a motion to dismiss. And we'll talk about that more when we get there. But the moral of that is, do your work now, be less embarrassed or not embarrassed at all later, because your complaint will be scrutinized, and we're going to practice how it will be scrutinized. In a true motion to dismiss, it's scrutinized by the other party, the defendant's counsel. It's scrutinized by the court. And then because those types of hearings, motion to dismiss hearings, usually they're in the presence of a courtroom full of lawyers. The other lawyers are going to hear whether you did a halfway decent job on drafting your complaint or not. And as I said, most complaints may see a motion to dismiss. And some judges might give a motion to strike or take part of the complaint out or give you a chance to clean up part of your complaint, because those negligence allegations aren't easy to write. But what you don't want is to have the improper format, not provide numbered paragraphs, not follow the form that I've given you, not go in the order of duty, breach of duty, proximate cause damages. If you have any questions, you know where to find me. And if you need me, you know where to find me.